Appeal for judgment, Carlos Hampton and Jason Lewis versus the Queen.
The Judicial Committee of the Privy Council is about to give judgment in a case which comes from Jamaica. We are aware that Jamaica has just experienced a severe hurricane and that the storm is likely to affect other parts of the Caribbean region very shortly. On behalf of the Judicial Committee, we would all like to say that our thoughts are very much with you as you prepare for the storm and also recover from its aftermath. On the 2nd of April 2001, the appellants were found guilty of murder and were sentenced to life imprisonment. They were ordered to serve 25 years in prison before being eligible for parole. In March 2003, the Court of Appeal refused the appellants' application for permission to appeal against their conviction and sentences. The appellants then sought permission to appeal to the Judicial Committee of the Privy Council. Their application was lodged very late indeed, so the first question for the board was whether permission should be given for it to be lodged late. Rule 11.2 of the board's rules provides that an application for permission must be filed within 56 days of the date of the order or decision of the court below, or the date of the court below refusing permission to appeal if later. This is known as the 56-day rule. The appellants had written to an English solicitor in July 2003, that's very shortly after the decision, to ask for her help with their appeals. But it was not until April 2010 that she instructed another firm of solicitors to represent the appellants in these proceedings. The state's solicitors were not aware of the appellants' wish to appeal until the appellant solicitors notified them in July 2011. Very shortly after that, the applications for permission were filed. But that took place 8 years and 4 months after the order of the Court of Appeal of Jamaica. On the 16th of August 2012, the board decided that it was in the interests of justice that the appeals should be heard, and it granted the appellant's application for permission to appeal. Having considered the merits, however, in the judgment which is being delivered today, the board unanimously dismisses their appeals. The board wishes to make it clear that it has no intention of departing from the 56-day rule. In cases where the respondent objects to the lateness of an appeal for permission, as a general rule, the longer the delay, the more convincing and weighty the applicant's application for the delay will need to be. But the circumstances that contribute to the problem of delay in criminal appeals from the Caribbean are exceptional. These include limited or a complete lack of legal aid, the need for the appellants to rely on pro bono representation, and in Jamaica, the difficulties of prisoners in communicating with the outside world, and the lack of a procedure for prisoners to be informed of their rights of appeal. The question for the board, as when dealing with any other late application for permission, is whether, having regard to all the circumstances, it is in the interests of justice that the time limit for filing should be extended. In considering that matter, weight will always be given to the merits of the appeal and to the severity of the sentence. The stronger the case appears to be that the appellant may have suffered a miscarriage of justice, the less likely it will be that the application for permission will be rejected because it is late. Pro bono practitioners will be expected to progress their cases as quickly as possible, but it would be unreasonable, given the other demands on their time, to expect them to adhere to the same exacting standards as are expected of remunerated practitioners. The best way of reducing the opportunity for delay lies in the early exchange of information. The following steps can and should be taken to minimize the risk of unreasonable delay. 1. The prosecuting authorities should be notified as soon as possible that a prisoner has indicated an intention to apply for permission to appeal. The board will expect the prosecuting authorities, for their part, to provide help in obtaining as soon as possible the relevant documents. 2. A copy of the notification should be given to the board's registrar when the application for permission is filed. And 3. Those who normally act as agents for the state concerned before the board should be informed at the outset. They can be expected to offer help to obtain as soon as possible the relevant documents if problems are encountered with the prosecuting authorities. The board would like to add this: it has every confidence that those who regularly practice before it will continue to maintain the high standards of professional conduct and mutual cooperation, which do so much to assist in the handling of appeals that have to rely on the pro bono system. The board will now adjourn.